Donald Trump sues Judge Engoron, files a petition in the New York Court of Appeals saying that the gag order that he placed not only on Donald Trump, but on his defense team as well, as it related to this woman right here, Allison Greenfield, the judge's GF. He said, don't you dare talk about her. Don't you talk about our love notes, okay? If she wants to kick me in the foot here in the middle of trial and nudge me about an objection or something else, she's free to do that, okay? We have a very serious relationship. And so this was a wild gag order. Alina and the rest of Trump's defense team couldn't even believe it, because not only was Trump gagged, but the lawyers were gagged, and the lawyers were gagged from even objecting about the conduct. So what were the lawyers supposed to do? How can you represent your defendant if you can't even make objections about the misconduct that's taking place in the court? It's basically insane. And so what happened was there was this emergency proceeding, and we started to unpack all of this on a prior segment here, but we now have the actual lawsuit, right? This thing was filed. This is what caused the gag order to be lifted, to be stayed for an interim period of time while they process this. This is a 2,000-page document. We're going to read through the highlights of it, really hit the crux of the petition, and then look through some of the transcripts. But it is big, and this is really what's going to be debated, all right? So Tish is going to respond to this. Judge Engoron has been ordered to respond to this. Like, explain yourself, sir. Like, what do you think this gag order is justified for? How do you think it's constitutional? And so we'll read through that. And Trump is also responding to this, right? Now that the gag has been lifted, he has some of his free speech back. And so we'll go through on this, but this was the original order as we saw it come down. And there was a brief oral argument yesterday, kind of caught everybody by surprise because we were still in the middle of trial with Tish. And this is what the judge wrote. He said, considering the constitutional and statutory rights at issue, an interim stay is granted. And of course, people on the left were going, oh my gosh, Trump's going to murder 1 million people tonight with this one truth post. And he did. He published a truth post at 4:44 p.m. And he said the following on his truth account. He said, Judge Arthur Engoron, affectionately here known as Areola, has just overturned, stayed by the New York State Appellate Division for the 4th time on the same case. His ridiculous and unconstitutional gag order, not allowing me to defend myself against him, and his politically biased and out of control Trump-hating clerk, okay, that was illegal. He got fined for that twice already. $5,000 for the first offense, $10,000 for the second offense. The Court of Appeals currently has everything stayed, right? So it's not that he's going to get all that money back or that he's been found to be victorious, but the judge said, what I'm seeing at this point is a pretty big problem. And now he's right back out there talking about the judge's GF, the judge's Greenfield. He says, who is sinking him and his court to new levels of low is a disgrace. And by the way, she was the same person who donated over $3,000 to Democrat causes. Democrat causes, by the way, which were opposed to Trump, supportive of Biden, and even supported Tishy Latish James. Now, here they are defending, they say, the worst and least respected attorney general in the United States called Letitia James, who is a worldwide disgrace, as is her illegal witch hunt against me. The radical and unprecedented actions of Judge Engoron will keep businesses and jobs forever out of New York State. I have done nothing wrong. My numbers were low, not high. Talking about his valuations. I have a complete disclaimer clause, and the disclaimer clause, of course, says, hey, when I provide you my financial statements of disclosure to the bank, so Trump says, this is what I'm worth. I need a loan. This is my collateral. I need this loan in order to finance this deal, and here's what it's worth. But in that document, he says, you can't trust this document, okay? This is like my interpretation. You know I'm Trump. I like big numbers. I round things up. So do your own due diligence. If you think that this is worth $2 billion loan, well, you can give it to me, but that's on your due diligence. This is like my analysis, my assessment. I disclaim everything in here. And in addition to that, Trump explains that their star witness, Michael Cohen, who is a convicted perjurer, he admitted he lied, and he made up this fake case against me to get the whole thing started, which they admitted. And the attorney general used a, quote, get Trump platform. That's Tishy Latish. You know her from her facial spasms, where she says illegitimate president for all the time when she was running to prosecute him. She ran on a get Trump platform to run for the AG and for governor, and she failed on that one. Now, this wicked attack on democracy must be ended now. And so, of course, this is new, right? So Trump now is actually talking about the law clerk. And again, people are like, oh my gosh, she's probably gonna be dead in any minute now. Yeah, somebody protect her. Send the FBI over there. So, you know, this is Trump responding to this, as is his right? He is calling out what he believes to be misconduct in the court, and it certainly looks like that based on what we've been seeing, right? This is Judge Engoron. He's got her on the same bench. Remember, she ran for office. She wanted to be a judge. She's LARPing, live action role playing, trying to pretend to be a judge. She is not a judge. Judge Engoron probably is not that bright, so he needs kind of a second in command. So the whole thing is totally askew, and Trump has filed this petition in the Court of Appeals, which of course at this moment has been granted. And so we're going to go through through the full thing and see what they're asking for, which is basically reversal of the gag order. But they're also going to be using this, right, in support of their motion for a mistrial. And the mistrial is going to be asking that the whole case just be dumped, basically redone, because it is unsalvageable. There's nothing else that we can get into. And so we're going to jump right into this Court of Appeals opinion. But first, let's hear this quick message from our friends. Cereal is one of my favorite meals. It's fast, easy, requires almost zero prep, uses only one utensil, and it's very easy to clean up. It's basically perfect. But the problem I found with my morning breakfast routine is that many of the cereals I was eating are packed with sugars, but not the cereal from Magic Spoon, the sponsor of this video. This cereal is not just delicious, it's fueling my day with 13 to 14 grams of protein and only 4 to 5 grams of net carbs per serving. They have flavors like fruity, frosted, cocoa, peanut butter, all with the Magic Spoon flair that brings back that childlike nostalgia. It's perfect for anyone who's into a keto-friendly, gluten-free, or just a conscious eating lifestyle, and it's also got zero sugar, as in zero. It has the taste I enjoy, but it feels so much better knowing it's made with only high-quality ingredients, and I'm getting a little extra protein in my mornings. And because you're part of the Watcher family, we've got a special treat just for you. Use code Robert to get $5 off any order. Simply click the link below or go to magicspoon.com/Robert to place your order, or scan this QR code right here on the screen to get your Magic Spoon with the discount linked inside. So whether you're looking for a premium breakfast that keeps you full, or you're on a diet like keto, or just cutting back on sugar, Magic Spoon fits the bill. I've been enjoying my morning cereal so much more since I found Magic Spoon. It's the perfect start to my day, and when you try it, I think you'll feel the same. And they have a 100% happiness guarantee on your order, because Magic Spoon is here to make your morning great. Don't forget to use my code Robert for $5 off at magicspoon.com/Robert, and I can't wait to hear which flavor becomes your favorite. Notice of petition, Donald Trump as the petitioners, but look at this. This is against the judge, Judge Arthur Engoron and Letitia James, right? He's specifically calling out the judge here, and the judge is going to have an opportunity to respond. Why are you doing this gagging, and why are you treating your courtroom like it's your little high school play? So they say, all right, your honors, this is going to the appellate division, so we're going up above Engoron to get into his boss, essentially, and they say, let's get to it. They say, we're asking the court for a judgment, granting the relief in the verified petition. This is what we want. On the first cause of action, we want you to annul the findings of contempt that the judge issued in October, annul and vacate their order, and do the same thing for the November 3rd date. Okay, so we've got two dates in there, 26th and the 3rd and the 20th. So three different kind of causes of action for three different violations: contempt, contempt, and contempt. I think there was a warning in there, then there was a $5,000 fine, and then there was a $10,000 fine. So they want all of that reversed. And here is what they say. And look who signed off on this. It's Alina. Haba. We got also Clifford Robert, who also signed off on the document. Now, this is their verified petition. They say, all right, judges, or judge, I think it'll be heard by a panel once it is certified and everybody has their responses. But here they say, all right, Court of Appeals, regarding Judge Engoron. Now, the assumption that respect for the judiciary can be won by shielding judges from criticism wrongfully appraises the character of American public opinion, right? Said another way, if you try to shield the judge from criticism, you're getting it wrong. For it is a prized American privilege to speak one's mind, although not always with perfect good taste, on all public institutions. We like to talk about these things. Now, and an enforced silence, however limited, solely in the name and preserving the dignity of the bench, would probably engender resentment, suspicion, and contempt, much more than it would ever enhance respect. This is what they understood back in 1941 in the United States Supreme Court. Yeah, obvious, okay? If you say we can't talk about it, we automatically presume that what you're doing in there is untoward, right? It is corrupt because you won't let us see it. We have a default presumption of access, right? That we can speak about this stuff and see it. And the people who are being punished can communicate to us about this stuff, and we can be the judges of whether it is legitimate or not that's taking place in there. But when you just try to say that you got to protect your own process and that we can't be involved in it, yeah, you're dang right. Resentment, suspicion, and contempt. 100%. And they're doing it to themselves. As we said here, if Trump was really an insurrectionist, okay, if Trump's really a monster and all these things, first of all, we could see criminal charges for it, right? If Trump actually was causing or actually harassed people, charge him with another crime. You've already done it 4 times, do it again. But they won't, because it's not actually harassment. It's not actually threatening. They're trying to make him responsible for third-party conduct and third-party behavior, which is insane. So petitioners, they say, so they can't do that, right? So they got to gag him, and they got to do it in the name of protecting the process of the court. Of course, they want to protect the process of the court because the process is corrupt, and we can see it, and they don't want us to call them out and interrupt it. So they tell us that petitioners bring this proceeding, this is Trump's team appealing this, to redress Judge Engoron's serious and continuing violation of the procedural and the substantive rights guaranteed to them under the law. Now, the conduct at issue here arises from the ongoing highly publicized trial of Trump pending in the Supreme Court. Now, on the second day of trial, Judge Engoron entered a gag order forbidding petitioners from posting, emailing, or speaking publicly about any members of his staff. This is known as the gag order. Then a month later, he expanded the gag order to then include the lawyers, Trump's lawyers, from also making any public statements in or out of court that refer to any confidential communications in any form between, quote, me and my staff, his Greenfield, who is passing him love notes, and maybe other things. We don't know. They were gagged from talking about it. The gag orders unconstitutionally infringe on Trump's rights, and they say Engoron may not, by judicial decree, transmogrify, and we wanted to look up that word, transmogrify, and I believe that word, yeah, it's to change thoroughly into a shape or form, there it is, often greatly with grotesque or humorous effect. Okay, so transmogrify the court's summary contempt power into an unfettered license to inflict public punishments on a defendant for Trump's out-of-court statement made for the benefit of the Fourth Estate. Nor does the court's summary contempt power, Engoron's, authorize the court and its staff to actively and independently investigate and prosecute violations of a gag order. They say Engoron here and the enforcement of the gag order has violated multiple sections of the judicial law. His extraordinary expansion of that order both limits and it chills the advocacy on petitioners' behalf and precludes counsel on pain of contempt for making a record of misconduct and bias in the public courtroom. And this is where the judge told Christopher Keese, "Don't do it, Chris! Don't you file it!" He's like, "I have to, Judge. Like, that's how this works." He's like, "Oh yeah, okay." Now, prior restraints, they say orders that suppress speech based on content and viewpoint, they are presumptively invalid. Like, the law has already just said that. If you're going to try to censor somebody and silence them from saying something, it's just presumptively invalid. Why? Because the First Amendment exists. Only a clear and present danger of a serious and substantive evil can justify such an infringement on the freedom of speech. Now, the constitutional protection, it's apogee, where the speech in question is core political speech made by the frontrunner and the Republican presidential nominee regarding perceived partisanship and bias at a trial where he's subject to hundreds of millions of dollars in penalties. The speech giving rise to the gag order, which was a post on Trump's True Social account, was a photograph of Judge Engoron's principal law clerk and the Senator Chuck Schumer. He said that she was Chuck Schumer's girlfriend and that she was running the case against me. Now, Trump's people say, by the way, she was the one who originally posted that photo of the law clerk and Senator Schumer on her public Instagram account when she was running for judge. The account explicitly linked to her unsuccessful failure 2022 campaign for the Democrat nomination. So she wanted to be a judge, didn't win, and now she's pretending. It was then reposted by a public Twitter account called Judicial Protest, and then ultimately reposted by Trump. Now, it's apparent to anyone that's been attending the trial or reading contemporaneous press coverage that the law clerk, the judge's GF, plays a visible role in the trial, as she sits immediately adjacent to Judge Engoron on the bench, and she consults with him on almost every ruling, passing contemporaneous notes. Now, they say that Engoron has also sanctioned Trump under the gag order for a comment that he made saying that somebody is very partisan sitting next to the judge. They say completely disregarding, they called Trump to the stand. "Were you talking about my law clerk?" He said, "No, I was talking about Michael Cohen, not the law clerk." And the judge said, "No, I don't believe you. I don't think you're legitimate," and fined him again. They say on its face, Court of Appeals, the gag order prevents any speech, no matter how innocuous or relevant, about any of Judge Engoron's staff. Not only just his GF, but everybody. Now, as applied to Trump, it also prevents a presidential candidate from commenting on the public conduct and the possible ethical violations of what's happening in his chambers. Now, they sit right beside him on the bench throughout trial as well. Now, while the desire to protect his staff may seem understandable, you can understand that, certainly, the gag orders as intended are not narrowly tailored. The mere potential that speech may anger or provoke other likewise does not entitle Engoron to suspend wholesale the rights that are afforded to litigants by the Constitution. The First Amendment does not permit Engoron to restrict this speech based on the audience's anticipated unruly action, otherwise known as a heckler's veto, right? right? A heckler in the crowd can stop the whole performance because he's offended. Oh no, I'm hurt. Well, I'm sorry that you feel that way, but don't listen to the show. Like, get out of here, right? Like, the rest of the audience is not going to be harmed by your speaking out, by your being offended, right? A heckler can veto the whole thing because some third party reacts a certain way and everybody has to react to the third party. The supplemental gag order, which prohibits lawyers, not just Trump, but lawyers, from making any public statements, even in the courtroom, right? They couldn't even say it in the courtroom, like no objections. He says, you can't talk about anything that refer to any confidential communications in any form between me and my staff. And that is like, man, the lady doth protest too much, man. What are you so upset about, Judge Engoron? If this is all legitimate, then let him bring it up, but they can't comment on it? It's like, whoa. Now, in the weeks after the gag order was entered, counsels for Trump repeatedly brought this up with Engoron, and they observed, on the record, the principal law clerk's unusual public presence on the bench. Look, the unusual constant note-passing love notes, eye-rolling, facial expressions, visible role in the proceedings, and that's just what we could see above the bench, okay? All right, they're up there a little bit. She's on the same level. We don't know what's happening under the bench and under the table there. Now, I don't want to presume anything, but I'm just saying we don't know. I'm just making an observation. And the people in the courtroom, they moved the camera, okay? After we could see it on the camera, they moved the camera around too, so we don't really know what's going on under there. Now, counsel's advocacy comported with their ethical obligations to competently and zealously represent their clients, and how can Trump's defense say anything if they're gagged? Now, in closing the record to any further commentary on the judge's GF, the gag order insulates Engoron from contemporaneous criticism and denies Trump and the appellate court. They're also stealing it from you, Mr. Court of Appeals, because you can't see what's on the record because we can't even object to this, trying to hide it. Indeed, Engoron has gone so far as to have his courtroom camera angle adjusted. He doesn't want you to see what's happening under the table, I'm telling you. Now, no longer reveals the collaboration between him and his GF while on the bench, and has instructed counsel that they cannot make an oral motion about the principal law clerk. Literally, don't talk about my GF. Now, the supplemental gag order also runs afoul of the black letter law, mandating that absolute privileges attaches to in-court statements by counsel. Like, you can't punish us for doing our job. But Engoron's enforcement of the gag order, they say, is plagued by myriad procedural and jurisdictional infirmities, and he has consistently violated the judiciary law and the rules of this Court of Appeals. They say Engoron has twice invoked his limited summary contempt power to level punitive fines against Trump, $5,000 and $10,000, for purportedly contumacious. What the heck kind of words are these? Contumacious. Man, these are some $3 words here. Stubbornly disobedient.
Contumacious.
There you go. Contumacious. Conduct that indisputably took place outside of the courtroom, and Justice Engoron's immediate view was never raised by any party to the proceeding, let alone by motion on notice. Now, Judge Engoron did not explain how the conduct, which consisted of an archived post on the Trump campaign website and comments to the media, how did they come to your attention, Judge? Is somebody complaining about these? Or are you just scrolling around, briefing and preparing for your newsletter with your areolas? We don't really know. Nor have any of his putative sources been entered into the record. So we don't even know like where these came from. Who is the complainant here? Nor have any of the sources actually even come on. So these circumstances imply that Judge Engoron independently reviews press accounts, he's scrolling, about the trials, and he conducts his own unprompted internet research into Trump's speech. You're busted, Trump. I'm following you on truth. Such activities dehors the record, and particularly inappropriate given the Supreme Court, in this instance, is the sole fact finder, which concomitantly imposes elevated duties of impartiality and fairness towards all litigants. There is no public record to support a summary finding of contempt. And likewise, Engoron, his so-called evidence is his own testimony that describes the proximity to his law clerk and the layout and the bench of the witness box. He's like, well, we're not that close. We can't really like touch each other that much. Unidentified statements describing a witness by his name. Yet another out-of-court statement to the press preceding the issuance of the gag order, and the Oxford English Dictionary was plainly inappropriate to justify a contempt finding, right? So it's out-of-court statements, some unidentified witness, and his own testimony. It's like, no, we need more than that, Judge. Additionally, while Engoron has never identified any actual statutory authority for punishing Trump, his findings do not comport with the procedural nature or substantive requirements for any of these contempts. In fact, all those considerations concerns were wholly ignored in this case. They say Engoron and the imposition of conceitedly punitive fines of $5,000 and $10,000 is far in excess of statutory limitations applicable to both types of contempt charges. Now, they say finally, inasmuch as Engoron viewed the purportedly contumacious, stubbornly disobedient statements, Trump's stubbornly disobedient statements, as impugning his integrity and that of his staff, it was error for Justice Engoron even to preside over the subject contempt proceedings. He should have delegated it to someone else. Engoron accompanies each abuse of his authority with a warning to President Trump that things are going to get worse for you, buddy, apparently until he imprisons Trump without abiding by any of the procedural protections to which Trump is entitled by law. Well, to show trial, I mean, yeah, they don't care. Engoron's abrogation of Trump's rights during a presidential campaign and Engoron's egregious and continuing abuse of the summary contempt power in a trial that has captured the attention of the nation and the world cannot be overstated. The imposition of gag orders and the continued enforcement of them exceeds his jurisdiction and violates the Constitution. His imposition of summary punishment exceeds his jurisdiction, violates judiciary law and the rules of this court, constitutes an arbitrary and capricious exercise of the Supreme Court's contempt powers, and accordingly, Trump requests this court annul and vacate the gag orders and the contempt findings and prohibit the enforcement thereof. They tell us about the facts. We know when the first gag order was implemented. It was through the Truth Social post. We also know that Engoron and his law clerk have been working together for quite some time. She was appointed in 2019 and has been working with him ever since. So they've got a nice relationship over those several years. In 2022, she tried to run for a Democratic nomination to the civil court in Manhattan. She wants to be a judge. Now, in connection with her campaign, and while serving as his law clerk, she created and maintained a website, an Instagram account, and a Twitter account called Greenfield for Civil Court. Now, they say that this was maintained as a public page throughout the time of Trump's Truth Social post. Beginning early 2022, she used this account on Instagram to post a bunch of pictures. On February 26, she posted a page that she was withdrawing from the Democratic primary, not doing so hot. But she continued to actively post on there. She was showing her political activities with things like the Village Independent Democrats. And she said, petitioning with Village Dems who've endorsed certain candidates. We also know that Engoron allowed his law clerk to make some serious donos. She contributed over $3,000 to Democrat organizations in 2022 and $900 in 2023. Those are prohibited contributions. And in fact, some of those contributions went to actively support Tishy Latish, the AG in the case. And they also went to oppose President Trump. And the case was pending while she made those donos. She also attended partisan political events literally while this case was pending, where speakers openly advocated for Joe Biden and commented on the fight against development for the profits of real estate. We also have photographs of Engoron's law clerk, his GF, at the Chelsea Reform Democratic Club. And look, she's having brunch with Schumer. Schumer's no fan of Donald Trump, is he? This is the judge's principal law clerk, known as Allison Greenfield. Greenfield, the judge's GF for civil court. So thrilled to attend the Chelsea Reform Democratic Club founders brunch today, honoring incredible and fearless lifelong public servants like Senator Schumer and Rep. Maloney. Nah, isn't that nice? Here's Schumer. These two belong together. Gosh. Now, that's curious, okay, because she's co-presiding over a case involving Trump. They say on September 27th, the principal law clerk called Greenfield, the photo was used in a post on an online platform called X. This is the photo from Judicial Protest. They said, why is Judge Engoron's principal law clerk, Allison R. Greenfield, palling around with Chuck Schumer? Hey, great question, Judicial Protest, at Judicial Protest. The original post remains visible on their page. Now, the same page routinely posts photographs of other people and other media about the principal law clerk, and the photographs and the posts have generated millions of views. So then Trump took the same post, posted it on Truth. He said, Schumer's girlfriend, Allison Greenfield, is running this case against me. How disgraceful. This case should be dismissed immediately. And then Trump reposted the link and he said, Greenfield for civil court, the same account that the clerk urged her followers to keep an eye on. So after learning about President Trump's repost outside of his courtroom from an undisclosed source, we don't know who told the judge about this. Maybe it was Greenfield herself. Was it her? Did somebody say, hey, Trump's posting about you, and she told the judge? Hey, I don't like this guy posting about me. Can you gag him, honey? Justice Engoron conducted the above reference off-the-record conference, despite Trump having constitutional constitutionally protected speech, Trump voluntarily and immediately deleted the repost on his own because he's a nice guy. But later that afternoon, Judge Engoron, sua sponte, okay, meaning the government didn't ask him for this. Tishy Latish and her bureaucrats didn't ask for this. The judge just decided, I'm going to do it. He entered an order prohibiting all parties from posting, emailing, or speaking publicly about any members of his staff. A copy of the so-called transcript is right here. He said the following, a compiled transcript. Judge said this about Trump. This morning, one of the defendants, Trump, posted to a social media account a disparaging, untrue, and personally identifying post about a member of my staff, which was her post in a public post. Personally identified, she posted it. Although I have since ordered the post deleted, and apparently it was also emailed out to millions of other recipients. Personal attacks on members of my court staff are unacceptable, inappropriate, and I will not tolerate them under any circumstances. Yesterday, off the record, I warned counsel of this, and it was disregarded. My warning was disregarded. My GF is upset. Consider this statement a gag order, forbidding all parties from posting, emailing, or speaking publicly about any members of my staff. Any failure to abide by this directive will result in serious sanctions. Little Engoron, right? Very, dictator-like. So Judge Tanya Chutkin, of the DC court, they are parlaying off one another, right? They are stepping on each other's shoulders on these cases. She imposed a gag order on Trump. She did the same thing. Now, that gag order was also extremely short-lived. A 3-judge panel in the DC circuit, which we'll talk about in the next segment, administratively stayed the gag order pending appeal. Now, they say that the imposition of gag orders on Trump has been widely criticized. Even the ACLU is joining in on this. And before Trump voluntarily deleted his post, it went out on an email. Now, that email was automatically archived on Trump's website. Then the law clerk, again, based on information obtained outside the record, the law clerk, she emailed them, again, based on information, emailed the parties on behalf of Judge Engoron that he had learned that Trump's deleted Truth Social account was still active on the website. A copy of that email sent by the principal law clerk is attached as Exhibit E. Oh my gosh. Okay, so she sent, now, all right, this is a monster document. We're going to hold off on that. So they say that the point is, literally, the Greenfield, the law clerk, is sending the email. Hey, you have my post still up there in violation of the judge's order. That's like her she's talking about. So the archived email and the Truth Social post were deleted the same night. They showed up the following day. They said, Your Honor, it was inadvertent. Nonetheless, sua sponte, again, court's own volition. Nobody's complaining about it, unless it's Engoron's GF who is. She says, you got to do something about this. He's like, okay, relax, I will. He goes out and he says, okay, first time violation, a nominal fee of $5,000. He says, Trump's rich, you can just pay it. So then he issued an order. He continued, we knew that this was on your website for 17 days. And if you do this again, there's going to be more serious sanctions. Now, Engoron referred to contempt as a future sanction. He called it a sanction and failed to reference any authority for the punishment that he imposed. He just said, I can do it. However, inasmuch as the order found a violation of the gag order and immediate punishment, it constituted a summary punishment for civil contempt pursuant to the law. So then they tell us about the second contempt finding, and this is Michael Cohen being on the bench. And here is what the bench looks like. So check this out. They say the principal law clerk, Trump made a statement about the person sitting next to Engoron. Now, the principal law clerk sits at the bench with Judge Engoron to his right-hand side. The principal law clerk has sat at the bench during pretrial proceedings for the duration of the trial. The arrangement is depicted below in the photographs published by Getty Images and the AP. These aren't our photos. These are your photos. And they're like two little lovebirds up there. It's like your colleagues, like literally like colleagues, right? She's sitting there, maybe even showing him his computer, handing him things, looking at him. It's very, very close, very close. And here's another image right there. In fact, she's looking at the computer more than the judge is. All right. Like this, look how this computer is even angled, right? It looks like it's to her, not to him. Clearly, it's definitely angled more that direction than that direction. And she's basically running the show. Okay. He's just sitting up there as, the gray hair. That's it. And so here we see the principal law clerk is given unusual latitude for a court attorney and often questions attorneys for the parties herself. Engoron turns to speak with her off the record during trial before ruling on virtually all evidentiary objections or answering questions about the court's position on various issues. And so, they have, mic mutes, and then the mic comes back on, and then they, will carry back on the record. So nobody can hear him. So the principal law clerk, the role in the proceeding has also been the subject of significant on-the-record discussion. For example, on October 25th, Trump's defense, Mr. Keese, he described the, quote, considerable tension caused by the law clerk's position on the bench. And he said, it's unusual for a law clerk to sit on the bench. That's for the judge. Now, judges work very hard to get on the bench. They have to run, get elected, right? And she didn't do that. So Mr. Roberts described his experience in New York State. He says that he had never had a situation where you're literally trying the case to two judges. He says notes are constantly being passed. It would appear the court is in consultation with the law secretary with each ruling. He further described that Engoron would appear to be leaning in one direction and then will get a note, or there will be an eye gesture or a roll of the face or something. Abba said, if we're going to make a complete record with the treatment that I've received from the law clerk, it's inappropriate. I don't like having eyes rolled. I don't like being yelled at by law clerks who did not earn the robe. Yeah, Alina, woo! Man, that's right. She is not a judge. She did not earn the robe. She's LARPing. She's live action role playing. You got no business talking to me like you're a judge to me. Now, in sanctioning President Trump under the gag order, Engoron found that Trump's recent statement was a blatant, dangerous disobeyal of his gag order, even though he was talking about Cohen. Engoron responded that he would typically interpret, Engoron is so preloaded on this thing, man. He's triggered. If you just say, anything about the courtroom, he's like, are you talking about Allison? Huh? He's just triggered. He said, alongside of me means my GF. Now, the matter did not come up again during the duration of the morning session, but then Engoron conducted an off-the-record conference with the parties, which was closed to the press. Nobody could report on it. Then which was off the record, and who knows what he said. So Engoron then permitted the public to re-enter the courtroom, and he went back on the record to resume the discussion. He said, we're going to hold a hearing right now, and I'm going to call Donald Trump as my first witness. And we were here, we go, what? He called him up. Engoron proceeded to instruct Trump. He says, sir, come on up to the witness stand. And he had him swear him in. They asked him questions. President Trump, he said, what did you mean when you said? And Trump said, what are you talking about, Judge? The person sitting alongside of you was Cohen, because he was on the witness stand, seated right there. Says, Engoron proceeded to challenge Trump's response. He said, I don't believe you. Are you sure that you didn't mean the person on the other side of me, my principal law clerk, Trump? Trump says, yeah, I'm sure. Have you in the past referred to her, my principal law clerk, as partisan or a partisan Democrat, Trump? He said, maybe unfair. I think she's very biased against us. I think we've made that clear. We put up the picture and you didn't want that up. I think they got it off her website, however. So we didn't necessarily agree, but we did take it down, Your Honor. And then Engoron began ripping off on this. He began testifying on the record, right? The judge is explaining himself. Judges don't have to do this. They don't have to go through all of this. They do this because they're doing something unorthodox, right? This is not normal. So then he starts opining about his physical proximity to his principal law clerk, which is like, ugh. Engoron says, well, I'm more interested right now in to whom you were referring, as you can see, and as everyone can see. First of all, my principal law clerk is very close to me. We know, we've been seeing it in the photos. In fact, he says, Miss Abba would refer to the notes back and forth and even the conversations between us, but you and I, we can see each other and we're close, but not as close clearly, and there is a barrier between us. Okay, so this judge is like burying himself in this. He's trying to get Trump to pin Trump on this idea that Trump was talking about Greenfield. And so the judge is making the argument. He's saying, no, you were talking about Greenfield because we're so close. And how do I know we're close? Because I'm passing notes to her, and there's a barrier between you and me, and there's not even a barrier between us. I mean, her hand is basically on my knee right now, as you can tell. And everybody's like, that's what we're talking about. Yeah, exactly, Judge. Thank you. Dum-dum. Thank you for proving our point. She is very close to you. She is referring notes to you. And there is not a barrier between you, and there should be, because the law clerk sits below you, and there is a barrier on the other side generally, because they are not on the bench like a judge. So Engoron, he's like explaining this. He then punctuated his testimony with a question to Trump. He says, so wouldn't that be at best somewhat ambiguous as to whom you are referring? This is one of the dumbest judges you've ever seen. Aren't you trying to be ambiguous? He says, don't you always refer to Michael Cohen as Michael Cohen? And Trump said, no. Sometimes I call him, whatever. Now, at the conclusion of his star chamber questioning, Engoron, acting as both the prosecutor and the jury, he declared that he believed none of President Trump's testimony, and he imposed a second summary judgment, punishment, for violation of the gag. Engoron says, as the trier of fact, I find the witness, Trump, is not credible, that he was referring to my law clerk, the principal law clerk, who is sitting much closer to me, who doesn't have a barrier, we know, whom I believe has been accused by Trump as being a partisan Democrat, which is true, as she is, because she donated $3,000+ and also ran as a Democrat. I hereby fine you $10,000, which is on the low side, to be paid within 30 days to the Lawyers Fund of Client Protection, because you offended me. Now, in a written order, Engoron memorialized the findings, and he said quite clearly, defendant was referring once again to my principal law clerk, who sits alongside me on the bench. Now, Engoron then reiterated that Trump's testimony under oath rings hollow and untrue. And what he did is he went to the Oxford Dictionary and he said alongside means close to the next of. And he said witnesses do not sit alongside the judge, they sit in the witness box. In contrast, the principal law clerk, they're rubbing his nose in this. It's so good. They're rubbing his nose in it. They say, by his own repeated characterizations, even the judge is admitting in his own written orders that the law clerk sits very close to him during trial. And so all the Court of Appeals judges are like, wait a minute, what? How close? They're all thinking about their law clerks. They're like, oh, how close do I sit to my law clerk? Like, I wonder why she doesn't sit that close to me. Justice Engoron further rejected President Trump's testimony because he made past public statements about Cohen, and he said, well, previously he calls Cohen by name. And then he said that the statement mirrored other language, and so he sanctioned him. But he said that the statement was unmistakably clear. Now, he didn't cite any statutory authority for the punishment. Why? There is no authority. However, inasmuch as the order found a violation of the gag order, it constituted a summary punishment for contempt. So then Trump and his team, they submitted on the record entry of the gag order. They objected on the record to entry of the gag order. They said there's no evidence to support your assertion. They said, Your Honor, Trump has a First Amendment right. He can comment on what he believes and perceives, I think legitimately from his perspective, as a potential source of bias, and limiting Trump's speech runs afoul of the First Amendment in general with respect to the defendants, but also even more under the heightened scrutiny of restricting and placing prior restraints on political speech. And they said, Your Honor, we need this gag order reduced to writing. We're going to be appealing this. And they did. So he wrote a total new order, and President Trump wrote to the court, says we are going to be appealing this, which is what we are doing now. On November 2nd, Engoron and counsel engaged in an extended on-the-record discussion about the principal law clerk and the gag order. A copy of the transcript is attached. But Engoron resorted to an ad hominem attack on counsel. He's name-calling him as follows. He said to Mr. Keese, this is Judge Engoron speaking, okay? And a lot of this stuff doesn't make it to the X scripts that we review here, of course. He said, Mr. Keese, Engoron, all joking aside, and even I like to leaven the proceedings, maybe lighten, do not refer to my staff again. A person sitting alongside of me is my principal law clerk. She's a civil servant. She's doing what I ask her to do, which is help me process cases and decide them correctly. Sometimes I think there may be a bit of misogyny, Chris. The fact that you keep referring to my female principal law clerk, if there is any further reference to anyone on my staff, and I don't have a big staff, I have about 3 people, I will consider expanding the gag order to include the attorneys, including yourself, Chris, Mr. Keese. Mr. Keese responded. He says, Your Honor, I do often feel, frequently, I do feel like truly that I'm fighting 2 adversaries, and I'm not trying to impugn anyone. I'm trying to point out as a lawyer, and I think it is a fair comment as a lawyer. I understand what your ruling is, but I have to respond to this because this is important. So I feel like I'm sitting here and I have to respond to Mr. Amir and their arguments. I hear what those arguments are, and I get to see what those arguments are, and we get to have your engagement. But then there was someone else who is sending you information on a very, very frequent basis. I think yesterday we counted 30 times, maybe 40 times. And so I don't get to understand what this is. And those, I'm not trying to invade it. All I'm trying to say, Your Honor, is that it gives off, respectfully, that gives off the appearance of impropriety. And I'm entitled to at least make a record about that. It is not impugning anyone. It does give off the appearance of impropriety if it is an individual or individuals that have a different point of view on the case than we do, have a different political background or political view than we do. And so those are relevant issue for Your Honor's consideration. Again, this is why I brought it up on the constitutional. I ask you to reconsider the gag order on the constitutional basis because I think it raises much more serious issues, and I don't really want to go there. And I'm not trying to, but at some level, I have to at least have fair comment on what I think is biased. Abba continues, Your Honor, I would be happy to make the record for Mr. Keese so that none of her team members, my team members, Alina, are accused of misogyny. Do you want me to make these objections? I'll make these objections. And she said, I have the same issues with the person sitting on the bench. Your Honor, I respect your position, but I do feel like, Mr. Keese, that your position is often what you are given in notes, and we don't have a clue what is going on, but we do know that there is a nod of the head by you when those notes are received and then decisions are made. We have to make a record of it because, frankly, it's become part, and I've said this for 3 years for me personally, a part of the record. And I'm not going to stand by and allow it to happen. I'm not going to let someone who's my teammate be called a misogynist because he is pointing out something, frankly, that I can do myself. So I will make my own record, she says. It is inappropriate. Shout out to Alina. Now, defending her co-counsel, Christopher Keese. Yeah? Call him a misogynist, call me a misogynist. Now, after further further discussions of the witness testimony. Mr. Key stated that I have to, on behalf of my client, comment on what's going on in this courtroom that I think could prejudice or bias the proceeding. Key said, I don't see what is being passed to you, so it is not possible for me to know. Now, Judge Engoron became irate. Okay, now he's furious. How dare you? That's right, he says. You don't see it. I'm going to pound the table. That's confidential communications from my principal law clerk. Absolute right to it. And you don't have any right to see it or to question it. Key says, I certainly have a right to question what is perceived by my client as bias. I do have that. I have to make a record. I do have that. That's just what lawyers do. I have to make a record. I don't think, respectfully, there is any security concern. We're talking about observations of what's happening in open court. Everyone in this room can see what I'm seeing. So it's not a security issue. I'm not commenting inappropriately. I'm directing my comments to you and only to you, but I have to make a record if I perceive that there is a potential bias. Shout out to Christopher Keese and Alina Abba. Now, on November 3rd, Justice Engoron then opened the proceedings with further comments on the principal law clerk. He says, not yesterday, but several days ago, I believe that one or two or all of the defense lawyers said that they had never seen a judge be so intertwined with his or her law clerk basically passing messages. I mentioned that to the judge for whom I was a law clerk for many years, and he reminded me something that happened many decades ago, saying there was an elected Supreme Court judge, which is what I am, in this very building, and I'll give away the genders. He was very well respected, and he had very high profile cases. Now, if I told you the name of the plaintiff and I told you the name of the defendant, everyone would know them. Now you're scratching your heads, right? Now the law clerk was running for the judge, and the campaign literature said, I'll almost quote this exactly, says, I sit on the bench every day with the judge and I whisper in his ear and I tell him how to rule. Now, of course, we haven't seen that, fortunately. The law clerk was elected, is still a judge. This is decades ago. And so just to claim that you've never seen anything like this, apparently that's even more extreme. Now, I didn't see this happen. I'm assuming that's what the story was and the judge never said so. She doesn't sit up there and tell me how to rule, but to finish up, I hope I made myself clear yesterday. That is a weird story, man. So he goes back like decades and like digs up this story about some clerk who says she whispers in the ear, and he's like, so it has happened before. Anyways, later, the court issued a gag order later that day. Now, after describing the two instances of summary contempt, he then imposed the gag orders upon the parties. Now, he says that's not going to go upon the attorneys, and then further clarified this later on. He says, Mr. Engoron further clarified in response to some questions from the attorneys. Abba asks the judge, Your Honor, I'll be more clear, if I may. I think that they are being extremely careful, and it's causing confusion, Your Honor, so don't sanction me. I'm doing this in the most delicate way possible, but Alina says, Your Honor, we know that we are going to be moving for a mistrial, just so you know. There's no, that is part of the plan. We don't want to put anyone at risk, which is what they are trying to get at. Now, outside in the way I read your order, which is different than they do, I think that you are specifically speaking about the contents of your notes being confidential, and that is what we are not to talk about, right? It's the content of the notes we can't talk about, right? He says, no, not just the contents, which I assume you don't know, but the fact that they exist. You can't even talk about the fact that they exist. Alina says, okay. He says, that's my business, not yours. So then Trump's lawyers, they asked Judge Engoron, does that mean that we could not refer to communications even if they're a necessary ground for a motion? Like we can't even put that in a motion, even though you've not heard these things? Like we have to create a record. That's why it's all on the record. So, Your Honor, of course, but if we were, for example, if we were to move for a mistrial based on the implications of what you just said, that we would need to at least reference the subject matter in order to file the motion. Like we at least have to talk about the notes if we're going to file a motion for a mistrial. He says there's no way to file that motion without referencing the subject matter. He says we don't. The judge cuts him off. Don't file that motion, Chris. Don't file that motion, Chris. Don't. Chris is going, I'm a lawyer. Engoron confirmed that he was directing counsel. Okay, that's an order from a judge. It's an order not to make any motion based on a ground that might be subject to the gag orders. This is the judge doing this all on the record. This is going to the Court of Appeals. Defense says, Your Honor, for clarification purposes, I just want to be clear. Then is it the direction and the order of this court? You're ordering us that if we were to move for a mistrial based on the grounds that are subject to the gag order, you are saying we are directed to not make that motion. Is that what you're saying? Court says, can you repeat that? They repeat that phrase. He says, yes, I'm directing you not to make such a motion because I'm entitled to do what you're referring to. The only subject matter of the gag order. I'm allowed to pass notes. I've already decided that I'm allowed to do that. You can't even object to it, so don't put it in the motion. So the attorney can't make a record about something that the judge is doing that he thinks he has the power to do that maybe he doesn't. So Engoron Engoron then modified his position, right? Then he probably got a note from his GF, and she's like, hey, dummy, you can't, like, they have to be able to file motions. Like, that's the whole point of why we're here. Like, this is a courtroom. Hello? Look around. Engoron then modified his position. He's like, oh, yeah. He then tells counsel, he says, okay, I guess you can make the motion, but only in writing by submission of a proposed order to show cause. She's like, oh, I guess you have to. I guess I can't do that. So Ms. Abba comes back. She says, okay, so outside of the notes then, Your Honor, other issues have come to our attention outside of just your love notes. Are we allowed to address anything outside of notes? Because they haven't been addressed with the court, and I think that's the clearest way to ask, Your Honor, what we are asking, which is we need to have an opportunity to be heard on those things that have not yet been heard. He says, give me a second to have a confidential communication. And he goes, that's fine, Your Honor, that's fine. Alina says, of course, yeah, have a confidential communication, have fun. So he probably leans over and talks to his GF. He says, okay, how's this? He says, I think this is fair, and I understand your concern. You can make that motion, Miss Abba. Thank you. And he says, and I'm sorry I yelled at you before. Miss Abba says, well, we'll do it in a very delicate manner. Okay, but it has to be in writing. I don't want to hear it in front of hundreds of people. What? It's in writing. We're reading it in front of thousands of people now. And so, yeah, do it by order to show cause, please. You can make it as quick as you can. Now, counsel stated that while that procedure was highly unusual, it was acceptable and provided the order to show cause was actually signed by Engoron. However, Engoron refused to confirm that he would sign it. The defense says, Your Honor, I've never seen an application for a mistrial done by an order to show cause like that, but as long as the order to show cause is signed by the court, I guess I don't see a problem with that. He says, well, I'm not sure that, I guess that there's a brief pause in the proceedings. He says, submit an OSC. It's not an order until the judge signs it. Mr. Robert knows that. Submit a proposed order to show cause to me. I'll get right to it and make a quick return. And they say, okay, well, based on all of that, these are our causes. So the judge is basically whacked Court of Appeals. Here's the deal. We have our couple causes of action, and they're saying we have the right to bring this, and they're giving us the law that tells us why we can end up in front of the Court of Appeals, which is where we're at now. They say an order that imposes summary judgment under the judiciary law is reviewable by the next level court. October 20th and 26 orders were in fact contempt orders that constituted arbitrary and capricious. They were affected by error of law. They were a violation of lawful procedure. They were an abuse of discretion, and so on. The order was impermissibly imposed ex parte upon Trump. Trump did not meet the standards, and that Engoron impermissibly imposed summary judgment upon him. They tell us, same thing with October 20th, again, improper punishment. Say here that the statutory maximum fines for these things is just $1,000. $1,000 for the first offense. He hit him with 5. So he's up. He's not even following the law. Same thing happened in October 26. The judge created his own ex parte investigation, right? He's singling Trump out, going to find out where he's violating his orders. The orders impermissibly impose punishment without hearings, without due process, without notice, without written charges, without counsel, without compulsory process. He violated the law and just sanctioned him. Now, here, another cause of action saying that he lacks the jurisdiction to even punish Trump under the power of his court. And we also have some constitutional problems. The First Amendment to the United States says that Congress shall make no law abridging free speech, and any imposition of a prior restraint to limit free speech is a problem. The gag order was explicitly identified by Engoron as a gag order. He said, the gag order stops everybody from speaking about his GF. Now, speech is unprotected where it could produce imminent lawless action under Brandenburg, but he wasn't talking about imminent lawless action. He was talking about disparaging, untrue, and personally identifying information by his own words. There was no harm. There's no threats. There was no violence. He was just upset. He was offended that someone called out his Democrat clerk. The gag order suppresses Trump's free speech on the basis of content viewpoint discrimination. It's unconstitutionally overbroad. It fails to identify any actual legitimate threat to Engoron's staff, and it wrecks Trump's First Amendment rights. It's overbroad. Trump has already been sanctioned according to this gag order, so it's not just his free speech, it's also money. The fact finder is as biased as you can get, including moving the cameras around, playing footsie with his law clerk, including bonus torso photos and Trump stories in his high school newsletter. They say Engoron also on his own is going out and trying to find violations. In his orders, he's cautioned everybody. All the posts that Trump shared were made by the law clerk during her time as the law clerk, and one of her posts with Schumer was even made while this case was pending. Her role is very unusual. Feels like everybody's trying the case to two judges. Even contemporaneous press coverage has called this out as well. Almost every ruling, almost every decision, they're passing notes. And Engoron is constantly communicating with her throughout the trial. Now, Trump must be, as a presidential candidate, permitted to comment on what he believes and perceives. A defendant in a high-profile trial is well within his rights to comment on the actual bias of a judicial appointee who sits immediately next to the judge. But Engoron, on his own, issued a second order and blamed Trump for something that Trump says he wasn't even talking about, limiting his free speech in his conversations with the press. Nothing about Trump's comments about the law clerk or about Cohen constitutes incitement or any type of other unprotected speech, and the gag order is also attacking the 2020 Republican frontrunner. This case has relentless media coverage, and statements made by this candidate during a political speech are worthy of First Amendment protections. Engoron has issued an order that is unconstitutionally vague, and it's not sufficient to provide notice about the prohibited conduct. And so we got even more causes of action here. They ask here, as they wrap it up, they say, for all of the foregoing reasons, the supplemental gag order from Engoron should be annulled and vacated. It's in excess of Engoron's jurisdiction under the First Amendment, and it violates the Constitution. And so they're asking the Court of Appeals to grant judgment in their favor on all four causes of action for all the different violations, saying that they want the summary findings of contempt annulled and vacated, and any other relief that the court deems just and proper. Signed by Alina, Abba, and Robert, Clifford S. Robert from Robert and Robert, all sent in and verified as an appeal. We do have some transcripts in there, so it's all there. I mean, it's all on the record. Like, it's all corroborated. And so that is what is taking place out in New York. Alina Abba, who filed that motion, was explaining how some of this stuff works. Now, this was an interesting exchange because this was right before the gag order was lifted. So she's talking about the motion for a mistrial, which is a motion that we read through here previously, and it's closely related to the gag order, right? Part of the reason for a mistrial is because of the gag order, right? They haven't been able to comment and do their due diligence in the middle of trial. And so Alina is explaining what's happening here from her perspective. This is what it sounds like.
Well, I can speak to the court. I can speak to the rules that need to be followed that have been broken. Generally speaking, you cannot have the appearance of bias. You cannot have, there's rules about political contributions. There's rules about doing things that show a bias towards someone. I can speak to what the judge has done, which is putting things into the Wheatley alumni newspaper that he is an editor of. There's articles about me. There's articles about Eric Trump. There's articles about the case while the case is pending. There are things you're just not allowed to do because the American public has to believe that when they go to court, they're going to get a fair trial no matter what their personal beliefs are. Obviously, I have my personal beliefs. Yeah. But if I were a judge, I'm not allowed to bring those in. You're supposed to look at law to fact. And there's a lot of evidence there, some of which I can't speak about, some of which I can, but I encourage everybody to read the papers.
In fact, in the papers, there's a video of the clerk talking about Letitia James, chanting in terms of, you know, Trump is going to go down. What specifically is she chanting?
So that's the one part of my gag order that I obviously cannot speak to. I think, let me just speak about the gag order for a minute. The fact that I can't speak about it is so crazy in and of itself. Right. I'm an attorney, I'm an advocate, and I'm a spokeswoman. So the president's attorney and spokeswoman cannot speak about things that I see that are inappropriate because I've been gagged. My gag is limited to that item. So unfortunately, all I can say is I encourage you to go look at the papers and it'll speak for itself.
Because the clerk is actually chanting. And you have reported in the past that the clerk had donated lots of money to Democrats.
That's been reported.
Alina, let me get your take on what Hunter Biden is saying now, because Hunter Biden's lawyer is calling for a federal judge to subpoena former President Trump.
Sure.
Hunter Biden says he wants a subpoena of Trump for testimony in his criminal gun case. In a letter to the judge, attorney Abby Lowell writes this: Mr. Trump has made a plethora of concerning public statements calling for an investigation or possible prosecution of Mr. Biden, both while in office and since leaving. Is President Trump expecting a subpoena from Hunter Biden?
You know, if they're going to put my client on the stand, and I have heard this, if they're going to put my client on the stand to discuss Hunter Biden, go ahead. Go ahead. You know, obviously it's ridiculous. They're trying to intimidate and trying to say, if you're going to attack our kid, we're going to put you on the stand. For what? Saying things that we've seen pictures of, checks that have come from the CCP, drugs, videos, hookers. I mean, I'm not really sure what their angle is there, but I would advise him to get new counsel.
Well, at this point, you've got a laptop, which basically lays it all out.
The laptop from hell.
Yeah, the laptop from hell.
So, all right. So they are going to be filing, I'm sure, more motions. Of course, the Court of Appeals from from the New York jurisdiction will be ruling on this. The gag order is being challenged. Will it remain in place? Only time will tell. Of course, we will be here continuing to cover this. Things are getting a little bit spicy. Trial next week should be a lot of fun. We'll be here covering this trial and all of the other Trump trials. Thank you for subscribing, checking out robertgovea.com, which is where you can get all the PDFs, access the mind map, sign up for our daily newsletter. That way you don't miss any segments. All the stories will be delivered to your inbox. We'll see you there and here on the next one.